Mr Milburn, we'd looked before lunch at that meeting in October 2000. If we could then pick matters up in December 2000, DHSC 0004451_074. This is a letter from you to the then Chief Secretary to the Treasury, Andrew Smith MP, and it refers to a meeting you'd held that day to discuss funding issues in relation to vCJD. We can see from the second paragraph you agreed to find money, £25 million from the Department of Health's budget to fund the revenue costs of introducing single-use instruments for tonsillectomies, but reserved the right to come back if single-use instruments were going to be
yes.
extended on vCJD avoidance grounds to other procedures. And then if we go to the last paragraph, we can see you say there that so that's the Chief Secretary, agreed that the costs of the compensation scheme we're trying to set up to deal with up to 250 cases should be borne from the reserve. Do you have any recollection now of how easy or difficult it had been to get agreement from the Treasury to providing funding from the reserve for the vCJD compensation scheme?
I'm not sure I do, but maybe that indicates that it hadn't been a fist fight. I can remember the fist fights. But I can't say with any degree of certainty. Although, of course, as we were discussing before lunch, obviously, variant CJD arising from BSE and the causation, that was something that was genuinely cross-government. And if you remember, in terms of who was leading on responding to the Phillips inquiry, I wasn't leading. It was my colleague Nick Brown, who was then the Minister for Agriculture, Fisheries and Food. So that might have made a more enlightened approach from the Treasury more feasible, possibly. But I can't say with any degree of certainty, I'm sorry.
Still in late 2000, but a little earlier than your meeting with the Chief Secretary, there was an exchange of correspondence between yourself and Baroness J. And I just wanted to ask you something arising out of those letters. So CABO 40/123_006. So this is Baroness J writing to you on the 23rd of October 2000. It refers in the text of the letter to her raising a question at our meeting on Thursday the 19th of October of the possible anomalies involved in creating a specific ex gratia grant system for people suffering with vCJD and their families. I was particularly concerned about those with hepatitis C. And then she refers to an advert in the Irish press and the Hepatitis C Compensation Tribunal, which was a tribunal established in the Republic of Ireland, and says, I thought you should know about the publication of these advertisements at a time which might create unwelcome comparative publicity about our scheme, and then refers to copying the letter to members of the ministerial meeting on vCJD. Now, first of all, we saw Baroness J obviously referred to earlier in the context of it being suggested that she talked, along with officials, she talked Frank Dobson out of compensation or financial support for haemophiliacs with hepatitis C. At a point in time when I think she was in the Department of Health.
Correct.
Now she's leader of the House
of Lords.
Leader of the House of Lords. Did you have? Was this a regular meeting that would take place to discuss health issues, or is it likely to have been an ad hoc meeting?
It wouldn't have been a regular meeting. It might have been, I don't know, but it might have been a meeting that was to do with health legislation that was in the House of Lords, possibly. For example, I don't know. I don't know what the reason would be for the meeting.
In any event, if we turn to your reply, which is CABO 40/123_013, You wrote on the 22nd of November 2000 back to Baroness J. The second paragraph, you say this, as you anticipated, comparisons have been made between the decision to make ex gratia payments to people with vCJD and our continued refusal to compensate people with haemophilia infected with hepatitis C through blood products. You give an example of an adjournment debate on the 9th of November. And then you say, however, I am convinced that both decisions are perfectly defensible on their own merits. As you know, our decision not to compensate people with hepatitis C stems from the well-established policy that compensation or other financial help to patients is only paid when the NHS or individuals working in it are at fault. It was simply not possible prior to 1985 to make blood products free from hepatitis C in sufficient quantities to treat all haemophiliacs in the UK. The plight of individuals and families affected by vCJD is, by the contrast, the result of a unique set of circumstances for which society as a whole must bear a moral responsibility. And then you go on to refer to the establishment of the scheme in Ireland. First of all, you've told us previously, and we understand from other ministerial evidence as well, that often, perhaps mostly, letters are written in draft form for ministers to then sign. This letter in the second paragraph, last sentence, says, I, as in you, am convinced that both decisions are perfectly defensible on their own merits. And you're writing here to the Leader of the House. Is this likely to reflect your own personally held view then as Secretary of State at this time?
Well, first of all, it would have been drafted. I wouldn't have done the drafting myself. I don't think I would have signed it if I felt that it didn't reflect my views. So, in some form or another, you've applied your mind to the issue, and we know you obviously have in relation to vCJD, but in relation to hepatitis C, you have essentially applied your mind to the continuation of your predecessor's line, and you are agreeing with it. Essentially, and if you remember, I raised the question in that meeting that we were referring to before lunch, vCJD internal meeting. I think it was me, from memory, according to the note at least, that raised the question about what the read across was to hepatitis C and the compensation requests. So, yes. And then, if we look at the next paragraph, you've got reference there to the well-established policy, and then the statement, simply not possible prior to 1985 to make blood products free from hepatitis C. Now, the issue about the 1984-1985 dates already been canvassed by reference to what was said in the hepatitis C strategy. Would it be right to understand, however, that you were proceeding on the basis that there were no infections with hepatitis C from blood products after 1985 or 1984, 1985? Well, I think I referenced that earlier in response to the questions from Sir Brian, that I think I had been briefed that was the case, certainly in the letter, if you remember, that I signed as Minister of State in 1997 to John Grogan MP, as a fellow Labour MP. As it turns out, the content of that letter wasn't wholly true, because I can now see, this is now, not a matter of recollection, I can now see from all of the papers that there were indeed some cases arising as a consequences of imported product, if that answers the question. But I wouldn't have known that then, I don't think. Yes. I'm not sorry.
Not just imported product, as it happens, but also the product manufactured in Scotland at PFC.
Right.
And indeed, it was...
Between 85 and 87, is that right?
That's right.
Yes.
Now, you've got those dates right.
Yes.
I've
got those dates right from
reading
this now.
Reading.
Yes.
Because, of course, after that, at around this time, and I forget precisely the date, you may have it at your fingertips, Ms. Richards, but there was a study done at the request of the Scottish Government into whether the Scottish Government had been at fault in not taking steps earlier to eliminate hepatitis C from its own manufactured product.
Yes.
But that news never reached you, at least when you were in post.
No, it didn't.
Maybe the dates don't coincide, but
No, I don't know whether we're talking about the same thing, Sir Brian. So the answer is no. I wasn't aware of. I don't think I. Let me rephrase. I don't think I was aware of there being a problem with Scotland exporting to England product that created problems. So
it would have been within Scotland, I think.
within no.
It may have been for those who did on occasion use Scottish product in England, because that was done, I think, on the evidence we've heard. But I think the general tenor of the evidence is there's no great extent to which it was done.
I thought I'd read somewhere that there possibly had been cases of Scottish product coming into England, but maybe I'm wrong.
Some but few, I think,
Some,
is the feeling
yes.
that the evidence has given us.
Yes, but more substantively on the second point that you raise, which is, do I think I was aware at the time that there had been a Scottish inquiry? I think the answer to that is no, I wasn't, I don't think, aware at the time. I am aware now, again, because of the volume of papers that I've been able to go through. I was going to say at my leisure, but not quite, in terms of spending time on it. And I think that I'm right in saying that that inquiry concluded that there hadn't been fault on the part of the Scottish NHS.
That was its conclusion.
Yeah.
But but what it was looking into, of course, was the fact that people had had infection transmitted to them by blood products made in the UK, for which you took general responsibility, albeit with a focus on England, between 1985, the start of 1985, and the date in late 87 when it was finally introduced in Scotland.
Yeah.
You now have the date, do you, Ms. Richards?
We're going to come and look at some of the Scottish reports, so
we'll look at it then.
We'll look at it then, I think. But before we leave this letter, the fourth paragraph, the paragraph that refers to vCJD says this: the plight of individuals and families affected by vCJD is, by contrast, the result of a unique set of circumstances for which society as a whole must bear a moral responsibility. Now, I completely understand what you are referring to when you talk about the plight, and you've referred to it earlier, the nature of the condition, the lack of any treatment, the inevitability of death within a short period of time. But it's the second part of the sentence. Do you know what you had in mind by reference to the unique set of circumstances which was said to have given rise to that plight, or why it was you thought society as a whole bore a moral responsibility?
I guess I don't know. You know, the lapse of a couple of decades. I guess what I was referring to was the fact that this was, as I was saying earlier in evidence, that this was the product of a set of circumstances where people were consuming animal product that they had been assured broadly across society and indeed by government ministers that it was a safe thing to do. And it turned out that that wasn't true. So I guess that's what that's a reference to. Maybe I should have said that in clearer terms.
I'm going to then pick matters up in the middle of 2001. If we go to SCGV 0000243_051, and we turn to page 2. So this is a position paper provided to Yvette Cooper, Parliamentary Under Secretary of State with responsibility for public health, 2nd of July 2001. If we just go on to page 6, we'll see it's copied to, amongst others, Sammy Sinclair, who was your principal private secretary, I think, and Simon Stevens, who was your special advisor.
Correct.
Later head of it, the same Simon Stevens who subsequently
It is
headed
the same
NHS
now,
England.
Lord Stevens.
So if we just go back to page 2, and before we look at the detail of it, having regard to the fact that it went to both Sammy Sinclair and Simon Stevens, is it likely that you would have seen this, do you think?
I mean, it's possible. I have no recollection of that. And, yeah, I mean, my guess is that I didn't. As I was explaining earlier, a lot of stuff went into the private office that, or indeed could be copied to Simon, and I would never see it.
Now, we can see from paragraph 1, what's triggered this position paper is the judgment of Mr. Justice Burton, which I think was handed down in around late March of 2001. There's a summary of implications. If we just go to the bottom of the page, the last bullet point just above the head timing says, although this judgment only places a legal obligation on government to make payments to those awarded damages by the courts, it introduces further questions of inequity and increases the moral pressure to do so.
This is part of what I was saying earlier, that this submission was a direct consequence of that judgment, legal judgment. And I think Yvette, as the Minister, because this is a commissioned paper, this is not a paper that officials have spontaneously decided to make available to Yvette. She's asked it clearly, I don't know what the question was, but she's asked a question which I guess focused on this issue of the ambiguity caused by the judgment.
We can see paragraph 2 refers to there being considerable parliamentary concern on this issue, and we've seen that indeed throughout the 1990s already, particularly by reference to Lord Morris's campaigns. Yep. If we go to the next page, I just ask you to note for present purposes, Mr. Milburn, paragraph 4. I'll come on later separately to the issue of the public inquiry, but we can see it's being set out there. The Haemophilia Society are maintaining a high-profile campaign and calling for a public inquiry. And then if we go, please, so I'm not going to go through the discussion about Mr. Justice Burton's judgment. If we go over the page to page 4, please, Lawrence, bottom half of the page. Just want to pick it up under the heading inequitable outcomes. And so paragraphs 14 and 15 essentially identify who may be able to claim damages under the judgment and then categories who will not. And paragraph 15 explains that there will be some infected people who may not be ill who will qualify, some infected people who may be terminally ill will not. It will not end the campaign on behalf of infected haemophiliacs. It will intensify the campaigning on behalf of others. And the observation, these are foreseeable and undesirable outcomes. Meeting the claims of those who do qualify under the judgment will involve the government in significant financial outlay as above. But this will not resolve the long-standing problem of other patients like haemophiliacs infected with hepatitis C by blood. And then if we go to the next page, there are a series of options identified, 5 main options for action. Option 1, do nothing other than comply with the judgment, essentially. Option 2, public inquiry, lump sum and hardship fund for all haemophiliacs infected with hepatitis C by blood. Option 3, lump sum and hardship fund for all haemophiliacs infected with hepatitis C by blood and low-key inquiry. 4, lump sum and hardship fund for all or some haemophiliacs infected with hepatitis C by blood. And then we can see inferentially no inquiry because that's omitted as part of the description of the option. 5, hardship fund for haemophiliacs infected with hepatitis C by blood and who have severe liver disease. The options are said to be set out in full in an attached options paper. And then paragraph 18, if ministers wish to consider making payments to haemophiliacs with hepatitis C, option 5 is recommended because it re-establishes the government's stance on no-fault compensation, provides an equitable outcome for haemophiliacs in a way that the judgment does not, effectively diffuses the campaign on behalf of all haemophiliacs by targeting only those as sick as the victims of HIV/AIDS, and entails relatively modest costs. If we then go on to page 7, this is the attached options paper. I'm not going to read through it all. If we go to the next page, what we see are the pros and cons set out for each of the options. As I say, I won't read them out. If we just look at the observation at the bottom of each table for each of the options. So for option 1, underneath the table it said this option represents the legal minimum response the government can make to the judgment. If we go to option 2, again we see the arguments for and against set out. And underneath it said delaying any consideration of compensation until after a full public inquiry would share the disadvantages above. If we go to option 3 over the page and option 4, again the pros and cons are set out. The bottom of the page, the observation is lobby unlikely to press for an inquiry if their compensation demands are met. However, a small lump sum aimed at all infected haemophiliacs, including those who are asymptomatic, might be taken as an insult to the seriously ill, and so on. And then option 5, next page, arguments for and against set out, and under the table it said, in addition, this option allows government to recover the high moral ground, that is, that they take care of the exceptionally tragic cases, regardless of the vagaries introduced, I think there should be the word by there, other arbitrary influences like the CPA judgment. This is an easier line to hold than continuing to exclude those dead and dying from hepatitis C infection in blood. And then reference to the McFarlane Trust, which administered the hardship fund in relation to HIV/AIDS. So that's the options paper set out. Can I show you a follow-up document and then ask you in broad terms about it? If we go to DHSC 0042461_182, there's a further submission here dated the 19th of July. The first submission had been the 2nd of July. This is from Mr. Lister, but again it's to Yvette Cooper and copied to Sammy Sinclair, your Principal Private Secretary. And it would appear that...
And to Darren Murphy, who was my other special advisor.
Yes. And it would appear that Ms. Cooper had asked 3 questions and asked for a response to them. Again, I don't think I need to read all of it out, but the first question in italics, what would have happened if the no-fault compensation scheme had been in place at the time of the judgment? Would it have made a difference, and if so, what? Mr. Lister sets out a response. The next question is, by giving haemophiliacs money, what other groups would then want compensation? Would the floodgates open to several more groups of people, and if so, who? And Mr. Lister identifies in paragraph 2 that if money is given to haemophiliacs with hepatitis C, the immediate group wanting compensation would be non-haemophiliacs infected with hepatitis C by blood transfusion. There's figures given of numbers identified, 669, of whom 113 had received damages through the High Court. Mr. Lister then says, these numbers may be manageable within any scheme. More worryingly, it's estimated that there are between 4,000 and 5,000 other patients still living who were infected with HCV through blood transfusion who cannot be traced. Over the page, please. These people may or may not know that they're infected. A proportion of them could well come forward if a compensation scheme is announced. It is likely that the existence of a scheme would encourage people who have had a blood transfusion to seek a HCV test. And then there's a question raised as to whether there would be documentary evidence of transfusion. Now, would it be right to understand, again, you don't know whether you read this document?
No, I don't know.
But
I don't think so.
Looking at the paragraph I've just referred to, should it have been a matter of concern to the department and to any ministers who were reading this, that there might be a substantial cohort of people who didn't know they were infected?
Yes, but I think that was understood.
Would you have expected the department to be doing everything it could to try and ensure that such people might come forward, whether by a publicity campaign or whatever it might be, but steps to try and identify as many people as possible who might have hepatitis C?
I don't know what the department
was
doing, but that would be reasonable, I would have thought, yes.
And then if we just go down the page picking up at paragraph 6, having set out some other groups who were also seeking compensation, Mr Lister says, despite the existence of these groups, it would be possible to justify payments to haemophiliacs as exceptional, given that hepatitis C related illness, which can lead to cirrhosis and liver cancer, is a devastating, debilitating disease. Around 200 haemophiliacs have died as a result of this infection. At least as many again are likely to die in the future. And then the third question, it would appear that Ms Cooper had asked, if we were to make some sort of symbolic gesture, what could that be? What would a money package look like? What kind of sums are we talking about? And again, I don't think I need to read it out, but Mr Lister sets out there and over the page a response to that question. If we just go back to the first page, there's a handwritten question, do you want to do a note to S of S? And then it said his last box is on Tuesday at midday, now gone. I don't think there's any document which shows a note going to you on this particular topic. But it would appear that as at July of 2001, an issue is being raised, whether at Yvette Cooper's instigation or otherwise, for consideration by ministers.
Yes.
Even if you were not having the submissions put on your desk by your principal private secretary or by your special advisors, would you expect this to be a topic that would be coming up at ministerial meetings?
Not necessarily, because I think, as you can see from Yvette's questions, which are reasonable enough questions, as I was indicating earlier, when is the point that triggers a note from a minister to the Secretary of State? Usually at the point when they have reached a position and then they want to put something to the Secretary of State. And clearly at this point, Yvette seemed to be at least in interrogative mode. She was still asking questions. Now, the slight complication with this is that, as you can see on the bottom of the handwritten piece here, Yvette was, I think, at this point about to go on maternity leave. I think she was actually the first minister ever to take maternity leave. So she left, and then it was handed over to John Hutton, who subsequently dealt with it. So she was in the middle of asking some pretty pertinent questions, which really did arise from the earlier legal judgment. And I think these two, both the questions here and the previous submission, are actually, again, quite important documents. And I've studied them quite carefully. Not then, but I've studied them quite carefully now. And, I mean, the options that Bryony Ensor, the official, and I think she'd been brought in specifically to look at what the department might want to do in the light of the judgment. Okay. I mean, the fault line in her submissions is the obvious one, that all of the options were about people with haemophilia who had contracted hepatitis C. But obviously there were another group who were non-haemophiliacs who'd contracted hepatitis C. It's almost akin to the difference between the Macfarlane and Eileen trusts, if you like. You know, that was a two-stage process, was it not? And I think therein lies a very important general point, which is this, that any of those options might have been fine, I don't know, and I think Bryony, presumably with Charles Lister, who actually responds here, so I presume that Charles had looked over it. You know, the last option, which was option 5, which was a very limited, focused option. I mean, of course you could have done that, potentially, but it wouldn't have ended the matter. Because with each one of these decisions, questions, options, and obviously the judgment earlier in the year had highlighted this very graphically, every time you did something, including, frankly, what I did in terms of variant CJD and the care package and so on and so forth, it begged a further series of questions. And where it took you to in the end was this really, I think, difficult place, which is you were in a bit of a stick or twist situation, because if you were twisting, you really then probably, in order to really sort the matter, you would be going for something that looked pretty much like no fault compensation. You were you'd say, actually, this needs to be settled. There's a really serious issue here. On the face of it, the scale of the tragedy and the solution that is being offered, there's quite a gap. Okay. The obvious problem with that is that it would have begged further questions about which other groups could raise perfectly legitimate concerns, and it would have had big implications for the nature of how negligence claims were dealt with by the National Health Service. And so I think, I don't know what if Vet was thinking, I don't know what Phil Hunt or subsequently Hazel Blears was thinking, but my sense is that every time one did something for perfectly the right reasons, because there were very good reasons why something should be done, it begged a further set of questions that became quite fundamental questions. And so this then took you to, wouldn't no fault compensation actually have just been the answer? And I know that that is an issue that has been around for very many decades, in fact, and I think from memory it was part of the recommendations of the Kennedy report on Bristol. And government didn't action that recommendation, and it didn't action that recommendation for a number of reasons that are very ably set out in Liam Donaldson's Making Amends report. And it's not just about financial cost, it was about other issues as well. The financial cost was a major one. So in the end, it seems to me now, looking with the benefit of hindsight at all of this, people in the department, officials, ministers, you were sort of in a no man's land. And there wasn't really an obvious way out of it, because the consequences of going for full-blown no-fault compensation for people here would have vast implications, which would, of course, potentially impact on other groups of NHS patients. And this is always the problem as a decision maker in healthcare. At its most bold, the needs are pretty infinitesimal and the resources are not. So you're having to make judgment calls, which are quite fine calls, around some pretty fundamental resource allocation decisions. And I think, having looked at all of this again, both this useful submission from Charles Lister and the previous one from Bryony, that is what comes to my mind, at least.
I don't think we have, at least in the papers that you've been provided with, an explicit answer to these submissions. But in reality, it was option one, the do nothing option, that continued as the status quo.
I think in the end that's what happened, and I think, having read the submissions, including the subsequent ones, which I don't know whether you're going on to or not, which then went to John Hutton, and I don't know what was in John's mind, but he is a lawyer by background, and he may well have come to the conclusion that I'd just come to at the time, which is, oh boy, we can sort of eat away at this, and there is a very good set of cases being made here, but in the end, it all begs a quite fundamental question. And that's why John, in my view, very sensibly referred this particular issue arising from the judgment earlier in the year to the CMO's review of clinical negligence, and specifically the question of no-fault compensation.
And again, I think it's clear from the documents we've looked at, this continued to be looked at within the department on an assumption, obviously on an assumption that there was no negligence involving government or the NHS, but also it would appear, is this right, on an assumption, a shared understanding that there was no fault in a broader sense, no wrongdoing in a broader sense on the part of the department or the NHS.
I think that continued to be the line to take. Correct.
Just picking the matters up briefly then in relation to what you just referred to and John Hutton's involvement, there's, if we go to DHSC 0004363_090, if we go to page 2, we can pick this up at the bottom of the page, just in some email exchanges. We can see it said that MSH doesn't think offering compensation is an option. However, he asked that you look into providing a social care package, a social care support package similar to that of the vCJD scheme. And then if we just go slightly up the page, we see reference to MSH being about to speak to Susan Deacon, Scottish Minister.
Yeah.
He just asked me for a progress update. He definitely wants you to investigate compensation for those eligible, those who contracted hepatitis C via blood transfusions who didn't take their cases to court. Now, I don't need to go into the detail of how thoughts may or may not have been developing, but the reference there to speaking to Susan Deacon, you observe in your statement that essentially by this time there are various developments in Scotland that,
yes.
that now begin to assume
Yes.
a certain amount of significance.
And just before you go to that, maybe, but I think what this also speaks to is the fact that so you now have two ministers, and I think Phil would be a third, who are continuing to prod away at this because they know that there's something unsatisfactory here, for obvious reasons, which is good, and I'm pleased that they did. Although, of course, I wasn't necessarily aware that they were doing it. The problem that everyone was struggling with is what on earth was the solution.
Now, we're now into October 2001. We don't need to go to it, but that's when you announced the compensation scheme for vCJD.
Correct.
For the transcript, but we don't need it up on screen, Lawrence, the announcement is NHBT 0008988. And then if we go to ARCH 0003326, please. If we go to the second page, we can see this is the 2nd of October 2001, and this is the Health Committee of the Scottish Parliament calling for financial support for all hepatitis C blood transfusion sufferers. Financial and practical support should be provided for all NHS patients who contracted hepatitis C through blood transfusion services, regardless of whether negligence can be proven. And then the second paragraph explains that the Health Committee was calling upon the Scottish Executive to put in place mechanisms to provide such support within 12 months. And then there's a quote from the committee convener, Margaret Smith, having considered the issues raised in 2 petitions to Parliament, our committee is persuaded by the moral case for providing financial and practical assistance to those individuals infected with hepatitis C through blood transfusion services. And then she continues, we're not advocating no fault compensation or anything wider ranging. Third paragraph of the quote from her says, we're seeking to correct an inconsistency in the operation of an existing narrow precedent, namely the precedent created when the UK government set up the Macfarlane Trust. So it was essentially a decision or a recommendation to extend that which was already being made available to those infected with HIV through blood products or blood, Macfarlane, Eileen, to hepatitis C sufferers. Now, you told us earlier, Mr. Milburn, about the joint ministerial committee of the health ministers of the 4 constituent parts of the United Kingdom. And we can see that this was an issue that was due to be discussed at a joint ministerial committee on health meeting. If we go to DHSC 6262-783, I think I've got that right, Lawrence. Joint Ministerial Committee on Health, 22nd of October 2001. If we go over the page, we can see the expected attendance. I'm not going to read out all the names, but we can see a range of UK ministers, including yourself, Chief Secretary to the Treasury, Northern Ireland ministers, Scottish ministers, Welsh ministers, all in attendance. The next page lists a range of officials. I don't propose to go to that. If we go to page 4, we see the agenda, just to get a sense of the breadth of issues that were being discussed. So there's a whole range of issues there set out, 6 lessons from Bristol and Alderhay, and then item 8, Consumer Protection Act, High Court ruling, and Hepatitis C compensation. But before we just take a quick look at what the paper on topic 8 said, my understanding from your statement, based I think upon your understanding from the documents, is that it looks like the meeting may have run out of time and item 8 didn't get discussed.
I mean, I guess that must be the case. I was chairing the meeting, so it was probably lamentable chairing on my part. But as you can see, it was quite a full agenda.
The issue relating to item 8 begins on page 50 in terms of the paper. And we can see it's a paper, just under the heading and note by the secretaries, it's a paper by officials in the Department of Health. If we go to the bottom of the next page, we can see, picking it up at paragraph 8.6 refers to the Scottish Parliament Health Committee paper that we just looked at in passing. And then under the heading Major Issues, the Scottish Executive Decision, that refers to paragraph 8.5, I should have made that clear. So that's settling Consumer Protection Act claims in Scotland. The Scottish Executive Decision is equivalent to the new status quo in England following the High Court ruling. However, the Scottish Parliament Committee report puts pressure to move away from the policy that the NHS does not pay compensation where it's not at fault, i.e. that there should be no payments to haemophiliacs and others with hepatitis C or those who have not initiated legal action under the CPA. That line would be difficult to sustain in the rest of the UK if the Scottish Executive commits to the Scottish Parliament report. And then more detail is set out in relation to that. And then if we can just go to the next page, paragraph 8.15, which is the penultimate paragraph. There's reference there to the Haemophilia Society's Carpet of Lilies campaign seeking financial settlement for haemophiliacs. The other aims are a public inquiry and the provision of synthetic clotting factors, so recombinant. I'm not going to ask you now about a public inquiry, but I just note that because we'll come back to that issue. So the expectation, as this right, had been that at this meeting in October there would be a discussion amongst all the ministers about this issue, but as it happens, it didn't take place.
I think that's right.
If we then, I think, pick matters up at SCGV 40247_039. This is really just to complete the paper trail. You referred earlier to what John Hutton decided.
Yeah.
Oh, and we can see this is an email on the 13th of November 2001 to Mr. Lister. It says, thanks for your note. I'm not going to take time up going to the note itself, but for the record, the note from Mr. Lister is at DHSC 0004601_021. This is Mr. Hutton's acceptance of the recommendations made in the note.
Who's this from?
This is from, it's someone called Jane Coleman. So it would appear to be being sent on behalf of MSH, the Minister of State for Health.
No, I was just confused by the reference to Bob Stock at the top, because he's a Scottish official,
He is,
I think.
yes.
Yeah.
Yes, sorry, he's copied into this.
Got it. Yep.
as are others within the Scottish Government.
Yeah.
If we go down the page, so thanks for your note. MSH agrees your recommendations, and we can see that the first 2 bullet points are the only ones I need to look at. To hold the policy line that no payments will be made in respect of hepatitis C infection through blood and blood products except where awarded by the courts, and then to refer the hepatitis C litigation case to the Chief Medical Officer's Advisory Group on Clinical Negligence as an example when they consider no-fault compensation. So I think that picks up upon what you said earlier.
Yes, and the obvious problem is that then Liam Donaldson came to a conclusion about no-fault compensation that mightn't have been what people necessarily were expecting to. By the way, it wasn't that necessarily I'm disagreeing with where he got to. So if you like, if the way out of all of this was to sort of change the rules of the game, then the CMO's conclusions in making amends didn't facilitate that. So you're left with the existing rules of the game, and then you're back to, so the position in England remains that compensation is only paid on the basis of fault. So.
So that's the position as essentially at the end of 2001. As your statement and the documents you referred to make clear, some things continued to be considered from time to time in the course of 2002. There was to be a debate in the Scottish Parliament. There was the report of, from the Haemophilia Society, a report of its Hepatitis C working party, and that was submitted to Hazel Blears.
It was.
But we can pick that issue up with Ms Blears when she gives evidence next week, I think, because you say you were not involved in the consideration of that report.
Not that I can recall.
If we do, however, just look at a note that suggests that there may be some conversation anticipated between you and Ms Blears. It's DHSC 0042275 _ 131. This is a facts cover sheet, August 2002. Again, just to put it in chronological context, in Scotland, there was now the expert committee, the Ross committee, looking in more detail at this issue of financial support or compensation in relation to hepatitis C.
Yes.
Bottom of the page says, attached is the note on Hep C in Scotland that you will need in front of you when you speak to S of S, so that's to you. This is a devolved issue, but it will be very difficult for us to have different positions. And that, I think, is anticipating what the Ross committee is likely to recommend. I think you have no recollection now of whether you had a conversation with Ms Blears on this topic, or if so, what that conversation was.
I don't, but I think this refers to a conversation that apparently did then happen because it was minuted. But I don't have a recollection. Is that the one that we're talking about?
It may be. I'm going to come on to...
Because somewhere in the papers that I've read, there's
yes, you're absolutely right.
Is that right?
Sorry, your grasp of the documents is better than mine. If we go to... We can pick it up in your witness statement, WITN 6942001, page 25.
And I think this must be a consequence either of an ad hoc meeting that Hazel and I had, or maybe it was a regular stock take, I don't know, but I can't recall it happening.
Yeah, and the reference here, there's also... no, actually, could we go, Lawrence, it's the same document but with a handwritten note on, could we go to WITN 6942013? So this is an email from Charles Lister, 6th of September 2002. It says, please see the email below from my opposite number at the Scottish Executive, that's Mr Stolk. He is asking for confirmation of our position on hepatitis C compensation to include in a paper for the Scottish Cabinet. I'm aware that PSPH, so that's Hazel Blears, discussed this with S of S, that's you, who was unequivocal in his opposition to a compensation scheme. Now, just pausing there, do you have any observations now on what's being reported contemporaneously, but by others, that you are unequivocal in your opposition?
Well, I mean, my first observation is unequivocal is not an inverted comma, so I don't know whether he was directly quoting from something that I actually said or from the tone of what I said. But I think at that stage, I'd come to the view that I've just expressed earlier, which is that, you know, it's to this sort of rock and hard place position that if you were to pay compensation for all the reasons that it was obvious that people thought they had good cause to receive, that had wholesale implications across a number of fronts. It had wholesale implications for the very operation of how we went about dealing with compensation, first of all. Secondly, it had implications in terms of the so-called cascade effect. How many other groups would then say, well, if it's good enough for this group, it's good enough for us. And, you know, that was a question that obviously a vet had asked, if you remember, in that previous paper that you showed just a moment or two ago. And it had implications more broadly for questions of how we were allocating and where we were allocating resources across the National Health Service as a whole. And I mean, maybe it doesn't need saying, but you know, let me say just two things. First of all, that these are questions about how you spend resources on behalf of NHS patients, plural. You're having to deal as ministers with sometimes competing interests, and that's obviously not straightforward. But secondly, you're having to deal with the fact that you've got a series of commitments that you've made more broadly to the public through the NHS plan and so on and so forth about where resources were to be spent. And finally, I guess you're dealing with some degree of uncertainty about what other potential meteors are going to hit you externally, which may bring further competing demands for NHS resources. So I read with interest, for example, in the papers, an earlier note from my tenure as Secretary of State from the Chief Medical Officer about the potential consequences of variant CJD being transmissible, whether carried through surgical instruments or whatever. And the costs, I can remember at the time, you know, feeling that these were major potential costs that I really had no idea how the NHS was going to be able to absorb, because he was talking about, you know, £800 million on improving decontamination services in NHS hospitals, equipment. He was talking about, I think, 675 million pounds if we had to go to single-use instruments, because there was a risk that the prion protein that allowed the infection to take place between humans, variant CJD, from one human to another, could be passed by a surgical instrument. So you were quickly into not the tens of millions or the hundreds of millions, but potentially the billions. And so the reason I say that isn't at all to belittle the arguments in favour of compensation, but is to try to contextualise them and to try to make it clear about how decision makers, including me, and probably primarily me, in truth, in terms of how one was having to grapple with these issues. So, you know, you were looking down a lens that was quite wide. You know, inevitably, of course, for this inquiry, the lens rightly is extremely narrow, focusing on this particular issue. But when you're the Secretary of State for Health, the truth is you've got competing interests and you've got to be able to grapple with those. So, and I think by this time I probably had reached the view that you were, stick or twist isn't a great phrase, but you know what I mean, that you were sort of, you were stuck between the existing position or something that was quite far-reaching, which eventually, of course, the Chief Medical Officer advised against doing in any case.
If we just continue with the email, it says the Scots are proposing to say the Department of Health in England has advised that it has no intention of initiating any scheme for compensating this group. From your knowledge of PSPH's conversation with SFS, is this sufficient, or should we be asking for the inclusion of a stronger statement along the lines of the Secretary of State for Health is firmly opposed to the introduction of any form of financial recompense for this group and has no intention of initiating any such scheme in England? And if we look at the handwritten bit, it says SW called this line, and it's the first of the two suggested lines, is fine. The other one, or the one's too strong, or something like that.
Yes.
SW is Stephen Waring in your private office,
Correct,
presumably.
that's exactly right.
So, whether or not you had seen this characterisation of your stance as unequivocal in his opposition, Mr. Waring would have seen it. Would that be right?
Mr. Waring would have seen what?
This email. It's sent to him.
Oh yes,
and
I
he's
thought
responding
so.
to it.
Yeah. No, and it probably, I mean, I'm guessing because I think these two phrases, I think they, and again, this is from memory reading the documents. I think, but maybe it's this email. I think somewhere there was a option put in front of Stephen, I guess, to give to me about which phrase I wanted to choose. So I think it mightn't, I don't know, it might have just been Stephen saying, hold on, that isn't really what the Secretary of State believes, or it might have been even me saying that that isn't what the Secretary of State really believes. So, and obviously the bottom line is, I mean, he doesn't say this, but it is OTT, one might say.
Can I then just ask you about something that's in a slightly earlier email from Mr. Lister? It's DHSC 00422751_132. There's an email top of the page from Mr. Lister, 31st of July, reporting on the Ross Committee's recommendation.
Mm-hmm.
If we go to the bottom of the page, there's an early email, 29th of July, and it's to the private office of the Parliamentary Under Secretary of State.
Yeah.
And it refers to what the expert committee is anticipated to recommend. If we just go over the page, I just want to ask you about something that's in the last paragraph. It refers to Scottish officials not knowing how Malcolm Chisholm's likely to react, that he's in a difficult position politically. There's a suggestion that the Parliamentary Under Secretary of State and Mr. Chisholm should talk. And then it says this: in the past, the understanding has been that any policy changes on this issue would be taken on a UK basis. That position can no longer be guaranteed. Do you know by whom and when that understanding had been reached, that policy changes would be taken on a UK basis?
Well, I guess that must be a reference to the pre-devolution position. I presume that that's what that's really referring to. But obviously, it isn't quite all fair with the times, is it? Because devolution had happened, and as we were about to see, devolution was to produce tensions between Scotland and England and the wider United Kingdom. I think, yeah, I think that's what he's referring to.
Now, we can take that down, thank you, Lawrence. The Ross Committee's preliminary report was produced in September 2002. I'm not going to put it up on screen. Again, for the record, it's HSOC 0003349. You don't think you would have read it?
I don't think I would have received it. I mean, it was a devolution had happened. So this was a report not to the UK Parliament, it was to the Scottish Parliament. It wasn't to the UK Secretary or England's Secretary of State for Health. In the end, it would have to be considered by Scottish ministers. there would be absolutely no reason, I wouldn't have thought, why that report would be sent to me, because that was for Scotland to consider. Now, as you know, in time, it had implications for England. I'd be very, I mean, I can't obviously recall whether I was sent it. I'm pretty clear that I didn't read the Ross report. And as I say, I'd be surprised if it was even sent. Obviously, it would be available to my officials because they would need to understand what the implications were, etc., etc.
And we don't need to go back to the document, but the email that we just looked at from Mr. Lister, the second email, 31st of July, it's before the committee's report was published, which was September. But that email, which I think was going at least to junior ministers, but not I think necessarily to anyone in your office, says we've obtained a copy of the Scottish Expert Group's recommendation attached.
Right.
So officials on any view would have had it.
And I think that was, I think that was normal. I don't know what's normal nowadays because, of course, devolution is much more entrenched and, frankly, there's much more party politics involved now because there are different parties in charge of different governments in the United Kingdom. But in those days, it seems to me from reading the papers today that there was quite a free flow of exchanges between officials, as well as ministers.
Now, again, the email that we looked at it suggested that there may well need to be a conversation between the junior minister and Malcolm Chisholm.
Yes.
In fact, as we know, there was a discussion that you had with Malcolm Chisholm on the 4th of November 2002.
Yes.
And if we can come to that, it's DHSC 00422275_129. Now, this is from your principal private secretary, Sammy, so Sammy Sinclair. If we just look at the bottom of the page, please.
It's not actually my principal private secretary,
I'm sorry.
but a private secretary,
yes.
Yeah.
So from Sammy, on behalf of Stephen, is that Stephen Waring?
Let's just go up again so I can see it. Where is that reference to Stephen?
So it's the bottom of the page, sorry.
Sorry.
So it's where it says at the very bottom, many thanks, Sammy, on behalf of Stephen, who will be leading on this, but is a bit tied up at the moment.
Yes, absolutely.
So sent by your private office on behalf of Mr. Waring. Was Mr. Waring your principal private secretary?
No, he wasn't a principal private secretary either. Heather Rogers was the principal private secretary. These were the two APSs. Sammy and Stephen were the assistant private secretaries.
So if we then just go up and look at the text of the communication, SFS has just spoken to the Health Minister in Scotland, Malcolm Chisholm. Malcolm Chisholm said that off the back of a health committee, they'd set up an expert group to look at the issue of Hep C and blood products. The expert group has now completed its report, which, according to Malcolm Chisholm, says that Hep C is comparable with HIV. If accepted, this would mean something along the lines of payments of $10,000 to people infected with Hep C via blood products and $40,000 at the point they develop chronic Hep C. Malcolm Chisholm is due back before the Health Committee on Wednesday and feels he has to offer something, probably around payments to people once they become seriously ill. SFS was very clear that he thought this would be a grave mistake and that once the principle that we'd established had been breached, then we were scuppered and on a slippery slope to payments running into the millions across the UK. He said he thought Malcolm Chisholm needed to tough it out. Malcolm Chisholm said that the advice he had was that this was a devolved matter for the Scots. However, he wasn't sure this was right. SFS is very clear that we need to find some way of showing that the Scots don't have the devolved power to go it alone on this, and thereby prevent them going ahead with any kind of announcement on Wednesday. Grateful if you could look into this ASAP and then come back to us. And I think what's recorded here then gets set out in a chronology document produced by Mr. Lister that I know you've also seen.
Yes.
I want to ask you about some specific points about what's said here.
Sure.
First of all, however, do you have any recollection now of your conversation with Mr. Chisholm?
I can remember having a conversation with Malcolm. I really can't recall the content of it, but I can remember having a conversation with him. And I think you'll see from my diary of that day, which I think you were provided with over the course of the last couple of days, because I asked for that just to try to understand the context. I think it was an 18-minute conversation where I think we were due principally actually to talk about the consultant's contract. But anyway, this obviously came up.
And just again, I don't think we need to look at the diary entry, but for the transcript, it's AMIL 601 is the reference number assigned to it, and it shows a range of different conversations and meetings that you had scheduled for that day.
Correct.
As well as including, but obviously not limited to, the discussion with Mr. Chisholm. Bearing in mind you don't have any independent recollection of the conversation itself, doing the best you can, why do you think this was something in which you as Secretary of State were getting involved on this issue, rather than leaving it to the Minister of State or Parliamentary Under Secretary of State?
Well, what I'm not clear about is whether I initiated the call or Malcolm did. So I'm not certain about that to begin with. I think it would have been relatively unusual for me to have initiated a conversation about this. So I think there are one of two explanations. The first is that I had initiated a conversation with Malcolm and wanted to talk to him about the consultant's contract, because we were renegotiating right in the middle of that. And I think earlier that day, in fact, I'd had a meeting with the Prime Minister on how those negotiations were going. So it's possible that in the margins of that call, that Malcolm then raised this issue with me, would be explanation one. I guess explanation two is that Malcolm wanted to have a conversation with me because he wanted to alert me to the fact that this was happening. So I'm not entirely clear about what the genesis is, and I haven't been able to trace that from the papers.
Now, on one view, this reads as though you are laying down a firm line to Malcolm Chisholm, very clear it would be a grave mistake, scuppered, slippery slope, tough it out. It reads as though, on one view at least, you are doing your very best to talk Malcolm Chisholm out of setting up any form of Hep C compensation scheme in Scotland, because it would then lead to one in England.
Yeah, I think there were probably, again, trying to sort of interpret events from then through the prism of now. I guess there were three probably concerns that I had, I would guess. The first would have been he was about to go and make an announcement or appear before a committee, the health committee. So I think this call happened on the Monday or the Tuesday of that week.
I'm afraid I don't know which day of the week
I think
it
it was
is.
actually the Monday from my diary, because I think it was the first day that I was in the office that week. And he was due to go before the committee on Wednesday. So I guess I probably felt, hold on a moment. I know that I may have known that this has been in gestation, but calling me or having this conversation with me and not bouncing me, but telling me that this is immediately going to happen doesn't feel like a great situation, because it has repercussions. So that would have been, I think, the first concern. I think the second concern would have been the one that you identified, which is what are the implications of what is being done in Scotland for what happens in the rest of the United Kingdom, and specifically in England. And I guess what I wouldn't have wanted to happen is for Scotland to be dictating events in England, not least because from recollection, I'd already been burnt once in that regard when Scotland decided to go ahead with free personal care for older people, which is a position that Scotland took, thereby increasing the pressure on England to do likewise, even though that was not a policy decision that we in England had taken. So partially this was financial and partially it was political, about Scotland setting precedents that inevitably increased pressure, and indeed they did. And history sort of bears this out, and I think probably the genesis of what my successor did, John Reid, when he established the scheme that he did, the genesis probably lies in what happened in Scotland. So I think that was a real concern. The third concern that I wouldn't underestimate is in the bottom paragraph, which is about whether Scotland actually had the devolved power to do it at all. And I think Malcolm wasn't certain about that, as you can see from this, and indeed in subsequent correspondence, I think the following day, in fact, he wrote to Andrew Smith, who by then had moved from being Chief Secretary to being Secretary of State for Work and Pensions, setting out what Scotland intended to do and asking explicitly whether Andrew would endorse, I think was the word that he used in that letter, would he endorse the view that the Scots were inclined to take, which was that this was a devolved power. Because the argument, as you know, was, is it devolved? Do you have the legal power to do it? Or is it reserved? No, you don't, because actually those powers are reserved to the United Kingdom. And I think the problem here, as it became quite evident quite quickly, is that because of the way that not what the Scots wanted to do, but the way that they wanted to do it was through a social security route rather than a pure health route. Normally, social security powers were reserved to the United Kingdom. And that was the reason that Malcolm subsequently wrote to Andrew. And I think part of my concern here was, well, if you're not certain and I'm not certain, we need to clarify about who really does have the power to do this before any decisions are taken. So I think these three things were probably the concerns that I had, and they sort of merged into one another.
I think you said earlier, I don't know the exact words, but words to the effect of not wanting Scotland to dictate to England. Might it be said that this is exactly what you were doing here, England dictating to Scotland, saying don't go ahead with a scheme in Scotland because of the implications for England?
Well, in the end, of course, the Scots, because the law officers, so this became quite quickly a big constitutional issue. And by and large, law officers, as you're aware, the Advocate General in Scotland and the Attorney General in England for the UK government, they don't really become involved in trifling subjects. They become involved in matters of substance. And in the end, of course, it was decided that it was a devolved and not a reserved power. So there was no ability on my part to dictate to the Scots. And in fact, the Scots decided to do what they decided to do, and you know, the scheme that they set up, which in the end, I think, you know, didn't necessarily satisfy everyone, went ahead. I think the broader point, however, is this. But here we were in the foothills of the devolution journey. This was pretty new. You know, we were getting used to how did Scotland work with England, particularly in the context where it was the same political party. Malcolm had been a colleague in the House of Commons. How was all of this going to work and bed down? So there was quite a lot of sort of constitutional uncertainty, so to speak. And I think, having thought about it subsequently, it may well be the case that almost whatever change was being proposed, certainly from the Scots, would have begged constitutional questions. And interestingly, I think, when I've looked at it again, when John Reid, decided to introduce his scheme in England, he had to, and indeed rightly, went out of his way to have conversations with his colleagues in Scotland, in Northern Ireland, and in Wales. That wasn't dictating, to flip the question. It was exploring whether or not this was going to work. So I think that would be an unreasonable interpretation.
But the conversation that's recorded here, it's not a conversation which says, note what you have to say, it's a matter for Scotland what it does. We better check, however, that Scotland's got the powers, that it's a devolved matter, not a reserved matter. Let's go away and find that out. I mean, this is you trying to, it may be said, trying to talk Malcolm Chisholm out of it as a matter of principle, quite apart from the question of whether it's devolved or reserved, which, as you rightly say, is a constitutional issue.
But with respect, it's Malcolm, if you look at the last paragraph. Malcolm Chisholm said that the advice he had was that this was a devolved matter for Scots. However, he wasn't sure this was right. He wasn't sure. So he was wanting to do something, fine, but he wasn't clear whether he had the ability or the powers or the constitutional rights to do it. So, understandably, perhaps, therefore, in the next sentence, I want to know, do the Scots have the devolved power to go it alone or don't they? And indeed, as you know, subsequent to this, as I've just been explaining, Malcolm himself was checking with other UK ministers, and most notably Andrew Smith, whether or not they agreed with that position.
If we just pick up the sentence beginning, Secretary of State is very clear, it's not Secretary of State is very clear that we need to find out what the constitutional answer is. It's Secretary of State is very clear that we need to find some way of showing the Scots don't have the devolved power to go it alone and thereby prevent them going ahead with any kind of announcement. So isn't it not the fairer reading of this is that it wasn't solely that you wanted to know the answer to the constitutional issue, and you're absolutely right, Mr Chisholm is raising a doubt about the constitutional position. You don't want this to happen because you don't want to have to go down the same route in England for all the reasons we've been exploring in the papers. So it's not just, is it, about getting the right constitutional answer. You actually don't want Scotland to go down this route, well, assuming it has the power.
So as I explained earlier, I think that I had three concerns. And if you like, they sort of merged into one another, of which this was one. So this was definitely something that we needed to assess. And to be fair, I don't think it would be possible for me as the Secretary of State for Health to browbeat the Attorney General into coming up with an interpretation of constitutional law that suited my purposes. That was for him and indeed his peer in Scotland, the Advocate General, to determine between them. And as you know, they determined in the direction that they did, which was in favour of this being a devolved power.
I'm not, I think, going to go to the documents that follow. I'm just going to read a couple of document references
sure.
with the dates into the transcript, perhaps before we break. And you do refer to them in your statement. So there is a further email on the 5th of November 2002 from Mr Lister, and the reference for the transcript DHSC 00208778_013, and a more detailed advice from Mr Lister of the same date, DHSC 00046001_003, which looks at the question of what steps might need to be taken to explore the devolution issue. And then the letter Mr Chisholm wrote to Andrew Smith at the Department of Work and Pensions, which is, again, 5th of November, WITN 6942015. There's a range of communications setting out different views on the issue about whether it was devolved or reserved, but I don't think it's necessary.
I think it took some time to resolve, didn't it?
Yeah, I don't think it's necessary to take time up looking at what different officials were expressing in different departments on the issue. On the 10th of December, Mr Smith wrote, I think, to Helen Liddell, who was Secretary of State for Scotland, suggesting a joint approach to law officers. That's DHSC 00422275_111. I think it's not entirely clear why, but that wasn't done until the 30th of January of 2003 in any event. And that request for advice to law officers, again for the transcript, WITN 6942021. There's some further communications in February. I think in your private office, Ms Sinclair, is trying to find out what's happening in relation to this issue. There's some further communications from Mr Lister saying we're still waiting for the law officer's advice. As I understand the position in terms of the dates, you then left office on around the 13th of June 2003.
Yep.
And the law officer's advice was received about a week later.
Yes, so I think it came after I'd gone. That's
my understanding.
Not a coincidence, or maybe it was.
So I've got a handful of questions arising out of this issue, but perhaps we could take the break now, sir, particularly having regard to the stenographers, and then I can pick those up after the break.
Yes, well, very well. We'll take a break now until 4 o'clock. 4 o'clock.